I love the fact that, Lindsay and Alexa, you're both here to talk about this today, and just the passion that you bring to your business has always inspired me. I mean, just knowing you for the years that I've known you, and I know how you engage with clients and wanting what's best for them, and really putting your skills to use in the advocacy that you not only work with them, and also the education of everyone else that's involved in a settlement. I mean, the settlement process, as you know, is complicated sometimes. It gets long or it could be short. It just kind of depends on the case that you're in. And a lot of times you have to kind of tell folks, what is about a certain subject and educate them on what's actually going to happen. So, Lindsay, maybe you could start here. So, we were talking offline getting ready for this, and I'd love to hear the story that you told about a recent interaction with your client with regards to contingent liability. I think that's a good place we can start. So, tell me what happened in that. What is contingent liability, and really what happened in this situation?
Yeah, so contingent liability is basically the insurance carrier or the employer remains on the hook, even if there's a structured settlement. Typically, with a structure, they transfer the liability for the periodic payments to the life company and assignment company. But if contingent liability is required, then in a work comp case, the insurance carrier or the employer remains on the hook if something were to happen and it were to fall through. And recently, I had a situation where the labor board in the state of Hawaii was requiring contingent liability on a case of mine. And there's no, law or regulation here that expressly requires contingent liability. So it's really up to the people making the decision and reviewing these settlements. And in this situation, both clients wanted the structure. My injured worker was ready to take control over his future medical, and he wanted a structured settlement in order to do so. And then the insurance carrier and defendant also wanted to, hand over that control to the client. However, the issue of contingent liability came up, and the defendant said no, like they were not willing to enter into a structured settlement if that was the case. They were just going to cash it out. Um,
Why was that a concern for them?
um, I think it's just they want to be able to move on from the
Yeah.
case, close their books, free up the reserves, free up some cash in a sense, and they don't want this precedent in a way to be set where every time they had a workers' comp case in the state of Hawaii, they would have to include contingent liability. And I mean, for those of us in the industry, we recognize how secure structured settlements are as a form of investment and as a form of stable income. Um, in fact, I honestly think it's a lot more likely that an insurance carrier or an employer might become insolvent than the life insurance company that's taken on the structured settlement. And so, in a sense, you're providing extra stability for the injured worker because they know that they have the peace of mind that the life insurance company paying their future medical payments or indemnity payments or whatever it may be is really highly rated and stable and just going to be making those payments every month in perpetuity. And
Yeah.
so,
Yeah. Okay. Well,
yeah, so
it makes sense, because on one side you have the carrier that doesn't want to pay a claim twice, and on the other side you want someone with this the injured worker who wants the stability and knowing that they're going to get paid, right? And so that's why they want the contingent liability on one side, and the other one side doesn't want it, right? So it sounds like this is a solution that addresses both of those concerns ultimately, and that helped kind of get that claim over the finish line.
yeah, and so what we did was I worked with the defense attorney and we just created some language for the settlement agreement that was being put before the board, which explained the different steps of security involved in the structure, the different, like the companies that were liable in the event that the initial company, became insolvent, and just the different steps that would need to be taken in order for that to be an issue. And I think just spelling that out in the settlement agreement and putting that language before the board really eased their concerns and made them see like that a structure is very stable, very secure, and the likelihood of anything happening was slim, but also that there are safety checks involved to protect the claimant. And really, I mean, the biggest peace of mind that the structure provides is just the stable income for the claimant. And if the defendant had not been able to come to terms with the board on the removing the contingent liability from that case, then the defendant would have cashed it out. The claimant would have gotten a lump sum of cash, which can seem great at the time, but when you're looking 10 or 15 years down the line and that cash is gone, there's the problem. Yeah.
Yeah.
So,
Yeah. I think it's fair to say that most people in the settlement process wants a good outcome for the individual that's been affected by whatever trauma that they went through. But uh, at the same time, you have situations where there's so many things going on at once. Ideas and narrative shift within the settlement. The negotiations get tense, laborious, even, and sometimes the needs of that individual get overlooked. Sometime. And Alexa, I know you have a specific story that I think is perfect for this. Of how do you keep the focus back on the claimants and really advocate for them in that heated moment of when settlement discussions are getting real and almost final?
Right. So the case that comes to mind is this mass tort that I've been working on. I've been working on for a few years now. I recall in the beginning, I approached the fund administrator and tried to explain how structured settlement annuities would work, how they would be a great tool, especially for a lot of the clients that I tend to do business with and do work for. I shouldn't say most, but a lot of my clients are plaintiff attorneys who bring me their minor clients' settlements. And of course, annuities are great for minors because it's a secure investment that will be held for them until they turn 18 and beyond. And we don't have to worry about anyone coming and, maybe like eating away from those settlement funds or whatnot. So I introduced myself to this administrator and, he thanked me for my time, but politely sent me on my way. And that was fine. But then sure enough, a year or so later, I have an attorney client approaching me and, not just wanting to do structured settlement annuities for his clients in this mass tort, but quite frankly, expecting to. And I explained to him, I did attempt to contact the administrator the first time. I was, politely shut out, but how about I help you in another way? How about we re-strategize how we can get the information to this administrator and ultimately explain that this is actually really good. This is a really great settlement tool for minors. So I may not have face-to-face time with the administrators and the powers that be, but fortunately, my client attorney who approached me, he has a seat at the table. So he has come to me in advance of when there have been scheduled meetings or telephone calls with the lead groups of attorneys, as well as the committee members and fund administrators. And essentially what I've been doing is feeding him questions and information behind the scenes. So he can go and attend those meetings and ask those questions, not just on my behalf, but basically raising the questions. These are really important questions that we need to figure out if we want to give anyone, his clients included, the opportunity for a structured settlement annuity. So that is basically the new way that I've found to get my foot in the door and get the information out to the people who need it.
I love that, and you two work together on cases. So things, and I don't know which side necessarily you come on. You work on claims on the defense. You work claims on the plaintiff side. Ultimately, at the end of the day, it's you that helps with and partnering with the parties involved to get this over the line. Is there something that you've learned in the last couple of cases or years of working together that has really just cemented you in the minds of your clients when it comes to, oh, I need to call Lindsay. Oh, I need to call Alexa about this particular case. What, what, what do they know about you that gets you that phone call?
Well, I will say that being the only structured settlement annuity consultants in at least located in Hawaii, as far as I know, right, Lindsay?
Mhm.
Is that a correct statement?
Yeah,
So,
that,
oh,
as far as I know. Yeah.
as far as I know, we try to corner the market, but I may be more plaintiff oriented, and Lindsay may be more defense oriented. But we do get referrals, each of us, from both sides. Defendants and insurers will contact me. Plaintiff attorneys will contact Lindsay, and we accept the cases. So, what's nice is that it allows us to basically keep our skills fresh. It's always the same work, but when you're allowed to see it through the other party's perspective, it always is just good for business and for our own personal practice. And as a practical matter, it allows us as business partners to step into the shoes or the case of the other partner. If one of us gets too busy or has to take a step back for personal reasons, we can step into the other person's shoes and pick up the case seamlessly. So the so our clients don't even realize that one of us has taken over the case for the other person because we have the skills to approach it and carry it through.
Well, Lindsay, you were telling me that that just happened, right? I mean, you had to step in recently for Alexa.
Yes, actually. Alexa had a medical injury case where a young man, he was probably about 30, so pretty young, had experienced a traumatic brain injury. And he wanted to do a structured settlement with his indemnity settlement. And on the surface, it seemed pretty simple. We had a claimant who wanted a structure. We had an insurance company who was willing to fund the structure and signed all the required documents. Everyone was on board. And then a structure was placed, and it turned out that it hadn't been obvious in the beginning when we first got the case, when Alexa first had the case, but it turned out there were quite a few defendants involved. Maybe there was a little bit of contention behind the scenes that wasn't obvious at first. But Alexa, I'll let you describe a little bit about what happened in the lead up.
Yeah. So thanks for giving that quick intro. There were so many insurers and defendants and parties involved. Thankfully, they all agreed conceptually to the annuity, and everything looked as if it was normal and going through. At the 11th hour, one of the defendants, who actually was not funding the annuity, but still was a party to the settlement agreement, wanted to insert additional language about the annuity, even though they were not parties to it. The annuity, we were up against a funding deadline. The language seemed innocuous enough, and all the parties agreed as well. So we pushed it through. Unfortunately, we didn't find out until 3, maybe even 4 months later that the life insurance company that was about to issue the annuity was not okay with that language, and which is fine. I mean, we can still save a case. And at that time, everyone was willing to re-execute a new settlement agreement, but then trying to find language that addressed the life insurance company's concerns as well as that insurer that wanted it added in was very challenging. Rounds and rounds of negotiations. Time is dragging on. The other defendants who, are parties to the settlement agreement but not involved in this annuity are now starting to get a little anxious and uncomfortable. Why is the annuity becoming this problem? Is what they're wondering. Do we even need to? Would it make things simpler if we just get rid of the annuity in general? And of course, it would have made things simpler, but to the detriment of our client, which we didn't want to let him get lost in us trying to argue about the nuances and the details of this terminology versus that terminology. So it just kept dragging on. And then I ultimately had to step away. And I'm so fortunate that my business partner and she was able to pick up right where I left off. So then, Lindsay, you took over.
And basically, in order to bring it to a resolution, we I just had to approach the other life insurance companies, explain the situation involved, and the show them the provisions that had caused, such a ruckus throughout this case. And it turned out that most of them were fine. The basics were there, the things that we needed to do a structure, the injured party, the company willing to fund it, like everything was there in place. And so we were able to place the business with another company. It took some fighting because, we had to fall on our sword a lot and constantly just push it through, because we knew that this is what the client wanted, that this is what they needed. And even though at that point, everyone was ready to wash their hands of it, we knew it was really the outcome that our client needed. And so we had to ruffle some feathers and show that it was still an option. And I think we were even given a deadline where we had to do everything in like a matter of days, where we had to find a new life company, find new benefits, get everything approved, get everything signed by 4 different defendants. Like everything needed to be signed, executed, and done before they were willing to reissue a check to fund the structure. And we were able to get it done. It took some around the clock working, but
it's stories like that just reaffirm your altruistic nature of wanting to help and ensure that your clients are taken care of, they're educated, they understand, doing what's necessary, not letting people get lost in the shuffle. It's just so inspiring. So I really, really appreciate both of you coming on, sharing your thoughts, your hearts, and your experience. So if you're in Hawaii, you both are just a phone call away. So really appreciate your time taken today. Thank you.
Thanks for having us.
Thank you.